Judgment in the appeal OB against Aventis Pasteur.
The judgment of the court will be delivered by Lord Rodger. When he was 1 year old, the respondent, known as OB, was vaccinated on the 3rd of November 1992 with a vaccine manufactured in France by a French company now known as Aventis Pasteur SA, APSA. On 18th of September 1992, APSA sent a consignment of the vaccine to its then wholly owned subsidiary Aventis Pasteur MSD Limited, APMSD, in England. APMSD received the consignment on 22nd of September 1992 and sold part of it, including the vaccine that was eventually used to vaccinate the respondent, on an unknown date. On the 1st of August 2001, OB began proceedings under Section 2 of the Consumer Protection Act 1987 against APMSD, alleging that the vaccine was defective and had caused him brain damage. On the 10th of March 2003, OB sought an order that APSA be substituted as a defendant in place of APMSD in the proceedings against APMSD, relying on Section 35 of the Limitation Act 1980. APSA contended that, insofar as English law permitted such substitution after the expiry of the time limit, it was inconsistent with Article 11 of Council Directive 85/374 of the 25th of July 1985. Broadly, Article 11 provides that there is a 10-year limit for initiating proceedings against the producer, as defined in the directive, of a product. A preliminary reference was made to the ECJ, and now eventually, after a second reference, the answer returned by the European Court of Justice is clear. It is that once 10 years have passed since a producer put a product into circulation, that producer cannot be sued unless proceedings have been taken against it within the 10-year period. Counsel for OB submitted, however, that in its judgment, the European Court had indicated a different basis on which he can actually make the desired substitution, namely that in proceedings instituted within the 10-year period against the wholly owned subsidiary of the producer, that producer can be substituted for that subsidiary if the domestic court finds that the putting into circulation of the product in question was in fact determined by that producer. The appellant contends, however, that this different basis indicated by the European Court has to be interpreted in the context of the judgment as a whole and in the light of the Advocate General's opinion. When that is done, the appellant says, it can be seen that the qualification should be given a narrower meaning, which does not, in fact, assist OB. The dispute between the parties therefore turns on the interpretation of that part of the European Court's judgment. For reasons which are too detailed to be able to be explained orally, but which are fully set out in the judgment, the Supreme Court unanimously accepts the appellant's interpretation of the relevant part of the European Court's judgment and allows the appeal. The Supreme Court sets aside paragraph 1 of the order of Mr. Justice Teare, dated the 20th of October 2006, substituting APSA for APMSD in the present action. The court will now adjourn.